Record shows you're Andrew Hendricks and you're testifying on behalf of ACLU Texas, and you're against the bill. But before you proceed, we have a duplicate on your registry. Can I have your permission to remove one?
Absolutely.
1 second. Okay, now proceed.
Thank you, Chair King, members of the committee. I want to echo a lot of what Representative Turner was talking about in terms of the Kennedy case. I think has been often oversimplified as simply it overturned the Lemon test and replaced it with a simple history and tradition test, and that is not an entirely accurate characterization of the case. There were 5 other factors that the court looked at in terms of determining that prayer in question in that case was in fact okay. 1, there was no student involvement. The court was very clear that because there was no student involvement, that was a factor here. The religious expression was quiet, brief, and personal. Not the same as when you're in a classroom and it could be potentially led by a teacher. The prayers occurred during free time outside of official duties. They were after the game. They were not before the game. And the court specifically noted that as being a potential issue. Religious messages were not part of a formal school program. And the 5th one is that it was not given to a captive audience. Captive in this sense, not meaning interested, but forced to be there. Granted, the permission slip program in this instance may lessen those captive audience concerns, but I would argue that there is coercion, and you make 2 middle school kids different from each other by saying one has to sit out school prayer. You have a chance for bullying. There's going to be kids who come home to their parents who don't necessarily want to sign that permission slip, but we'll be begging them to because they don't want to be just different than other kids. I would also say on the permission slip front that both the Supreme Court and the Fifth Circuit have held that requiring parental permission does not cure violations of the First Amendment for school prayer. In McCollum v. State, a state could not consistently with the First Amendment, the 14th Amendment, utilize the public school system to aid any or all religious faiths in the dissemination of their doctrine and their ideas.
Thank you for your testimony.
Of course.
Members, are questions of this witness? I see none. Thank you all for being here.